Welcome to Washington in Focus Daily. It is Monday, April 27th, 2026. I'm Carlene Johnson, the Center Square's state government reporter. And in today's episode, I got a chance this morning to drive into Seattle and meet with Washington Attorney General Nick Brown. He was holding a press conference today to announce a new lawsuit against Safeway, Albertsons, Haggen's, all the same ownership group, off over their buy one, get one free. Apparently, he says there's been some price fixing here and some violations of consumer protection. And so he's filed this lawsuit. That's not why I went. That ends up being a benefit for one of my colleagues, Randy Diamond, our Seattle reporter, who's going to be writing up this lawsuit because this is actually a significant story. But the whole reason I wanted to drive into Seattle and see AG Nick Brown was it because it provided the first opportunity since our breaking story 1 week ago today, and my colleague TJ Martinell, after obtaining the records from the office of AG Brown into how they collaborated with the sponsors of the income tax bill, how to craft the bill to maybe get around the state constitution, and also to avoid the public weighing in, attaching a referendum clause to that bill. So I did get a couple of questions into AG Brown this morning. He was a bit dismissive, but we're going to share that response with you in today's episode of Washington in Focus. And then the Department of Children, Youth, and Families. Now, the ongoing unanswered questions. We've been talking about this for months, about the funding for daycare providers who, in many cases, we have documented, don't appear to be legit. No state agency or state agency official wants to address this directly and say, you, the taxpayer, should know where your money is going. We need to be certain that these folks receiving these large taxpayer subsidies are, in fact, legitimate operations. Hundreds of millions of dollars of alleged or the potential for alleged fraud. But instead, in recent weeks, what we have seen from the office of Governor Bob Ferguson and the Department of Children, Youth, and Families is announcing tens of millions of dollars in new taxpayer subsidies to, in many cases, unnamed providers. Now, these folks are getting millions of dollars of your taxpayer money, and you don't get to know who they are. So we've been asking some questions. I did get some responses from the Department of Commerce to my inquiry saying, what gives? At a time when Washington taxpayers are, begging, pleading, demanding answers for these large taxpayer subsidies, why are we not getting them? So we'll wade into that. And then finally, a Thurston County judge is on Wednesday of this week holding an emergency hearing on one of the most contentious bills passed during the 2026 legislative session. This is a lawsuit against the sheriff decertification bill. We have an update there, an exclusive from the attorney who is handling one of those lawsuits. So stay tuned. That's coming up in today's episode of Washington in Focus Daily. So let's dive in. This Monday, today, started with a press conference in Seattle at the Seattle office of Attorney General Nick Brown, to announce that he is suing Albertsons, Safeway, and Haggen's, all under the same parent ownership group, over their buy one, get one free deals. I happen to shop at my nearby Safeway, do most of my grocery shopping outside of Costco there, and I take advantage of the buy one, get one free. Or in my case, since we're chipaholics in our house, we'll buy 2 bags of chips and get 3 free. He's suing him over that, saying it's deceptive advertising. But that's not why I went to the press conference. My colleague, Randy Diamond, is going to be writing about this fascinating lawsuit. But I went to specifically ask him about the documents obtained by the Center Square and my colleague, TJ Martinell. And we wrote about this last week, and through the week had a series of exclusive articles with reaction to the documents, which basically showed collusion, coordination, whatever you want to call it, between the AG's office and the prime sponsor of Senate Bill 6346, the income tax bill. And this basically showed that they went back and forth quite a few times. We had 988 pages of unredacted documents showing these emails saying, how should we craft this? You might want to add an emergency clause or a referendum proof clause to this bill. How should we word this to basically force this to the state Supreme Court? And that's where things are going at this point. So that was my motivation for attending the press conference. And I did get an opportunity to press AG Brown about the documents that we obtained.
Here for just a second, I asked you with the documents that the Center Square obtained. Do you think it's appropriate for your office to be giving lawmakers advice on how to break the state constitution?
Well, I would disagree with your framing of it, but it is very common for AG's offices to advise their clients on the law, the status of cases, analyzing prior Supreme Court decisions. It is something that we do on a regular basis. It is something that all of my predecessors have done. So yes, I think it's pretty common and appropriate.
A discussion of how to bypass the voters from your office, your attorneys in your office, and all saying this is what you need to do. You attach this referendum to bypass the voters. Is that appropriate?
That's just wrong. If you look at the email communications, my Solicitor General and people in the office were talking about how this, because it's raising revenue, couldn't go to referendum. So we weren't trying to bypass the voters. We weren't advising the legislature how to do that. We were explaining what the state of the law is. So the framing of the question and the reporting of that is just incorrect.
So it was not a huge surprise to hear his basically dismissal of my questions today and basically saying that it's not inappropriate or at all out of precedent for his office to weigh in on litigation. What I've heard from others that have, spoken to us here at the Square over the last week and a half since we obtained these documents is the part that's unusual is to have someone in the AG's office going out of their way to say, you might want to add this referendum clause, or here's where I think this is going before the state Supreme Court. Here's how you could push the issue. That's what is unusual in this case. And of course, of interest, I know, to a lot of folks who watch our coverage. So we're going to be staying on top of that. Now, Governor Bob Ferguson announced on April 16th, earlier this month, that through the State Department of Commerce and the Department of Children, Youth, and Families, they were awarding nearly $56 million in grants to 74 early learning and daycare providers across the state of Washington. Now, they said that these grants would produce more than 2,000 new childcare spaces and advance high quality childcare opportunities statewide. Given all the scrutiny for DCYF and some of the stories we've been covering in recent months, we kind of pressed and said, okay, so I want to know more about the providers securing these grants. Why should they be giving them? DCYF did not send me any response to my inquiry other than to say, here's the list of the providers, and then sent us to the governor's office. The Department of Commerce did respond, saying in part that because I pushed them on the whole fraud issue or the alleged fraud issue, saying, come on, you're providing these large taxpayer subsidies. People want answers. People want to know that these are not fraudulent providers and recipients of our tax dollars. And they did respond and basically say that, to qualify, they have to commit to continuing to provide services for 10 years. We follow through with these organizations. Don't worry about it, kind of a thing. And then they also sent me a follow-up response. We're going to put this graphic up on the screen because I pressed further and said, why can't we get the names of these providers? This is our money. And the response I received says the Public Records Act protects sensitive personal information of certain vulnerable individuals, including family child care providers, pursuant to 1501. This is a revised Code of Washington. Now, in order to ensure this information receives the appropriate review, the best way to proceed is to submit a public records request. And this came from Amelia Lamb at the Department of Commerce. Basically, nothing to see here. We protect them. We can protect them. Here's why we need to protect them. And you should, submit a public records request if you want more information. We've done so. We'll keep you updated. Also, my colleague TJ Martinell interviewed Senate Minority Leader John Braun, who's running for Congress, about this very issue and this subsidy request.
Yeah, it is. On one hand, it's kind of stunning that they would say that, but on the other hand, it's not really that surprising. Look, this whole thing with childcare fraud became a hot issue a few months ago, especially like folks were focused on Minnesota. But we have had uh, complaints from inside the agencies. First, was originally with DSHS, and then with the invention of the Department of Children, Youth, and Families some years ago. It moved there, but we've had folks inside the agency tell us that they have concerns about fraud. This is no new issue. It's things that we push forward. Time tracking programs, other audits have been suggested for years, and the uh, the Democratic majority has sort of pushed to the side. I mean, I don't, and I don't have any special knowledge. I can't say definitively it's fraud's there or not fraud, but we certainly have credible uh, claims that is occurring, and it makes sense to me that we investigate these regardless. If there is fraud, there should be consequences. If there's not fraud, the public deserves to know at this point that their taxpayer money is being spent reasonably and responsibly. Either way, it deserves investigation, and this just adds fuel to the fire that the Democratic majority shouldn't be sitting on their hands doing nothing about this. It deserves attention. It deserves attention now.
Lastly, for today's episode of Washington in Focus, a Thurston County judge is holding an emergency hearing on Wednesday, and we'll be there. This is for one of the most contentious bills passed during the 2026 legislative session. Outside of the income tax, this was the bill that allows Senate Bill 5947 that allows, I'm sorry, yes, 5974, the numbers juxtaposed, to allow the Criminal Justice Training Commission to decertify an elected sheriff. Couple of lawsuits. One of them is going to have a hearing in Thurston County Court on Wednesday. And this was the one that was filed by 4 Eastern Washington sheriffs. And the reason why the judge in Thurston County has granted the motion for an expedited hearing is because this bill is set to take effect on May the 1st. So the day before, there was a hearing on this lawsuit to say this is dangerous. This should not be implemented. Hoping to block this measure is attorney Mark Lamb. He is representing 4 of the sheriffs, and I want to play part of my conversation with attorney Mark Lamb on, basically setting the stage for what this lawsuit is, and then we'll move forward from there.
So I represent 4 the sheriffs of Spokane, Ponderay, Ferry, and Stevens County in a challenge to the legislation involving sheriff's decertification. And what that legislation does for the first time in Washington state history is place the ability to remove a constitutionally elected officer into the hands of a board that is appointed almost overwhelmingly by the governor. And the standards for which you could be removed from that certification would include who you speak with, what you write, and people that you might associate with. And the standards for both speech and association are very vague. They're very elastic, and they would lead to potential discrimination against people for exercising their political rights. They would also potentially implicate the free exercise of religion. So our argument is that this is a prior restraint on elected officials' right to speak, write, and associate freely with whomever they would like to, and that this imbues control in Olympia that would overrule the will of voters throughout Washington state for all of the counties of Washington state, and saying you don't have a right to elect a sheriff. And I think it's really critical as well for the office of sheriff. There's a direct linkage between the people and those who have the right to use deadly force against our fellow citizens. Wherever you fall on the political spectrum, we should want direct accountability to the voters for those people who control the only people who are authorized in our Constitution, in our system, to use deadly force against their fellow citizens, and that's law enforcement.
Now, Lamb told me he is most concerned about the kind of potential look back on social media. Social media posts, public comments that someone makes, maybe as a teenager, And then they decide, 15, 20 years from now to run for office, those comments could be used against them to preclude them from running, or certainly if they were elected, to potentially get them decertified. That's where we're at. We're talking about First Amendment issues here. And that's one of the main issues that Mark Lamb, the attorney representing these 4 sheriffs, is taking issue with.
Decertification means automatic removal from office. So somebody would no longer be the elected sheriff simply by virtue of the fact that they were decertified. And I think what's troubling as well about this law, it's not time limited. So if you're a younger person, like my children and others, you post something on social media, like a post from the Babylon Bee, that could then be used against you 10, 15, 20 years later to say, hey, you liked something that marginalized someone's perceived gender. And that means that not for something you did as a law enforcement officer, but for something you did in your private life, decades before, you are going to suffer the consequences for that. And you can, including removal of the voter's choice of elected office. What's really staggering too is that is not in any way, there's absolutely no accountability to that. There's no way to say the governor controls other appointees. They're not elected officials. There have been analogies that have been made to say, well, wait a minute, prosecutors have to be members of the Bar Association. Well, they do. However, to be removed from the practice of law, the Bar Association doesn't have that power. Only the Supreme Court of Appeals, which is elected, has that power. Similarly, if you are convicted of a felony, you can be vacant public office. But that goes then through a long legal process where an elected judge will supervise trial, help, where beyond a reasonable doubt, 12 of your fellow citizens say you are guilty of a felony. So there's no analogy. There's no, they've tried to use both of those examples for a variety of reasons. Neither of those examples is instructive. And also neither one of them, the Bar Association wouldn't have the power to bar somebody from being an attorney or disbar someone because of something they wrote on the First Amendment. And I know that because I've litigated cases with the bar on precisely that issue. And the State Bar Association, we may have our problems with them, but they have taken a very consistent position that First Amendment activity is protected.
I'll remind you, Democrats passed this bill along party lines after lengthy public hearings, contentious testimony in public hearings, and then lengthy debate on the House and the Senate floor. And it ultimately, again, passed on party lines. But we will be in the courtroom on Thursday when this lawsuit has a hearing in Thurston County Superior Court. There is another suit set as well, also filed in Thurston County, the Washington Sheriff's Association, and a gentleman by the name of Rick Cuss, who is a current King County Sheriff's deputy, but on the ballot at this point, running for sheriff in Kitsap County. Now, if this law ends up taking effect on May the 1st, there is not some sort of the judge makes a decision to kind of put this thing on hold this week, he may not be able to run his despite his lengthy military career and current status as a King County Sheriff's deputy, because he hasn't been in active law enforcement for a long enough time. This bill says has to be 5 years. So we're going to be there in court. Interesting to follow that. I can't wait to bring you updates later this week. As always, thank you for watching today's episode of Washington in Focus Daily. Have a great day.